Right. Let's go ahead and get it started. But let me do a quick introduction. Pretty much everyone knows everyone here
Mm-hmm.
already. Yusuf Hassan, I invited him here today. He's my co-host from Abolition Today and also a legal expert. And as I said last week, I would bring him in to show us some examples of how the 13th Amendment has been used as a block in court cases and allowing them to use indentured servitude, involuntary servitude, and slavery and human trafficking. So he's pulled out a few cases to show these examples for you. A little learning moment for us. And just want to say thank you, Yusuf, for giving us your time today for this.
Sure. Thank you for having me. Good seeing everyone again. I know almost everyone on the phone, on the call. Mark Hughes, I know of you. I maybe even spoken to you before, but let's jump right into it since our time is
limited. We
limited.
got guest on Abolition Today one time. He's the leader.
Okay, so yeah, I thought so. Okay, so let's jump right into it. Let me share my screen. And so you all know that the 13th Amendment, in all intents and purposes, took anyone that was subjected to incarceration. You know, they went from slavery, chattel slavery to imprisoned slavery just with the 13th Amendment. So as I'm going through, I'm just going to sort of like take a historical point of view from the 13th Amendment. I'm going to go through it quickly. I'm not going to get into my regular lecture like I normally would because we'll be sitting here all day. But some of the key things that happened right after the enactment of the 13th Amendment, which was December 1865, the Civil Rights Act of 1866 was passed by Congress. And U.S. Supreme Court Justice Potter wrote when they reviewed it in the U.S. Supreme Court that Congress has the power under the 13th Amendment rationally to determine what are the badges and incidents of slavery and the authority to translate that determination into effective legislation. So from day one, it was established that Congress is the ones who determines what is the 13th Amendment, how it should be applied federally and across the country. And so some of the first cases that were established dealing with the 13th Amendment, one of the first major cases that come out was the case called the Slaughterhouse Cases. And this is from 1873, and this was in Louisiana. The case involved a group of private butchers, blah, 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 blah. It was basically a labor issue. And they were saying, since we can only conduct our labor in New Orleans, that we're basically, if they claimed involuntary servitude. And so the court ruled that the main purpose of the 13th Amendment was to abolish African slavery and its incidents. But then the court went on to say that the Slaughterhouse case did not consider prison labor as an incident of slavery. So it made it crystal clear at that point that prison labor is not slavery. This is what the courts would determine. It says once a person fell under the exception clause, because at that time they called it the punishment clause, the state is justified in depriving the person of his life and liberty. But then doing further research, there was a case in Virginia called Ruffin versus Commonwealth. And it said, for the time that a person is during their service or serving their sentence in the penitentiary, he is in a state of penal servitude to the state. He has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those which the law and his humanity accords to him. He is, for the time being, the slave of the state. This is a court saying this. He is civiliter mortuus, and his estate, if he has any, is administered like that of a dead man. The Bill of Rights is a declaration of general principles given general principles to govern the society of free men and not of convicted felons and men civilly dead. So they're making it clear that the Bill of Rights does not apply to convicted felons or someone that's considered civilly dead. Such men are the slaves of the state, undergoing punishment for heinous crimes committed against the laws of the land. While in this state of penal servitude, they must be subject to the regulations of the institution, while they are inmates of the laws of the state to whom the service is due in expiation of their crimes.
Hey, Yusuf,
Sure.
before you go on, I just wanted to make a couple notes about what you just read there. First, it was only 6 years after the ratification of the 13th Amendment. So it wasn't like the 13th Amendment and slavery was not fresh in their minds. And they immediately stated that if you're an inmate, you are basically a slave of the state. Not even basically, that's what they said.
It clearly said it.
And it's as if you were a dead man. So you have suffered civil death and you're not entitled to rights, only the rights to which the law gives you. And that's where we're at right now in the United States. Thank you.
I'm glad you brought that up, Max, because here's some other things that they made another distinction. They made a distinction of what happens when a person violates a law or violates rules within a prison. And so they categorized it as whether or not it was a felony. If it wasn't a felony, then they said it is unquestionably in the power of the state to which its penal servitude is due to prescribe through its legislation the mode of punishment as well as the manner of his trial. If he commits an offense not amounting to a felony, the superintendent is vested by law with authority to punish him by stripes, meaning whip him, or the iron mash, or the gag, or the dungeon. If he commits an offense in which in law amounts to a felony, then he has the privilege of a trial by jury, a court of justice, to which special jurisdiction is given for that purpose. So this really established also the law stating that, you know, they can carry out their own punishments within the prison system. So they're a slave of the state. This is all mentioned in the same case. They're a slave of the state, and they can be disciplined in a manner that the state saw fit, except in cases if they committed a felony, talking about murder, things of that nature, then it has to go out to the courts.
Yusuf, I will continue to interrupt you throughout just to add
anytime, jump in. And if anybody has any knowledge on any of these topics, please jump in.
Well, what I want to, again, connect it to today, where, for instance, here in South Carolina, the men who were behind bars supporting the strike, the nationwide strike, used cell phones, contraband, and they shared via social media. And the prison gave them 1 year for every post. Some men got 30 years, another man got 40 years for the post. They didn't go to court for this. The prison decided what the punishment was and gave people life sentences for social media posts.
Absolutely. That's exactly the case. So at this point, we're in we dealt with 71 and 73. Fast forward to 1883. This is what was called the Civil Rights Cases. This was a collection of 5 federal cases in which the Supreme Court held that the 13th and 14th Amendments did not empower Congress to outlaw racial discrimination by private individuals. Yeah, you heard that right. So they're basically saying that, you know, you can racially discriminate against someone if you're a private individual. This is what was going on at the time, that there was nothing regulating discrimination at that time. It said the holding that the 13th Amendment did not empower the federal government to punish racist acts done by private citizens will be overturned in 1968 in Jones versus Mayer. And I'll cover that case later on. So the 14th Amendment not applying to private entities, however, is still valid to this day. While the decision holding for the 14th Amendment has never been overturned, in the 1964 case, Heart of Atlanta Motel versus U.S., the Supreme Court held that Congress could prohibit racial discrimination by private actors under the Commerce Clause. Though that and other loose interpretations of the clause to expand federal power have been subject to criticisms. So why is this important? This is the moment when the 13th and 14th Amendments were actually separated by the courts. Prior to this, cases were brought and they dealt with, as we all know, all of you here are very intelligent, and a lot of the stuff I'm saying, I'm sure you've heard before, but the 13th, 14th, and 15th Amendments were they're referred to as either the Civil War Amendments or the Reconstruction Amendments, and they were used as one. But this case was the one that separated the 13th and 14th Amendment. And so once you separate the 13th Amendment from the 14th Amendment, then that takes away the equal protection scrutiny that's afforded by the 14th Amendment. So I give you an example, for an incarcerated individual, if they want to bring a 1983 lawsuit, which is a lawsuit against the prison, against the officials, then they have to exhaust all of their remedies. And there are so many barriers to exhausting their remedies. And I'm sure Curtis and I'm sure Samuel can attest to that. There's so many things in your way to exhausting all of your remedies that a lot of times, by the time you can even exhaust your remedies, now your statute of limitations have passed. So the reason that violates a person's equal protection is, as a private citizen, if I'm out in the streets and I want to bring a lawsuit against someone, there's very limited things I need to do as far as exhausting my remedies. But in the prisons, you have to start with a grievance, and then from the grievance, then there's an appeal to the grievance, and it has to go up to the warden. It's a whole system that it has to go through before they can actually bring the
Some
case to
states
court.
don't have a grievance process like Alabama.
Damn. So again, and so Max, since you brought that up, what's the process of bringing the 1983 in Alabama? Are you aware of that?
No, I'm not, but I do know that the Department of Justice has investigated twice and determined that these are rampant Eighth Amendment violations happening, and we're still waiting for anything behind that too. So not only are the grievances not being heard, but a clear violation of their constitutional amendments shows that they have no constitutional amendments.
I think for the most part, people are having to bring forth like class action lawsuits. And I know an attorney he's trying to help a couple of people, but it's very difficult when there's only one person involved.
Absolutely.
As you can see.
Absolutely. And so
Yusuf,
sure.
1 second. I'll speak to the Alabama issue. If a state system does not have a grievance system, then a 1983 suit can go directly to the court system. But if there is a grievance system in place in your state, you have to exhaust every available remedy that you have. So the Alabama offenders or slaves or inmates could actually go directly to the courts. And that's kind of beneficial. It's better than most systems if the guys actually knew how to do it. And this process, people go to college for 8 years to become lawyers. So we got guys that are just coming in and they can't prosecute the cases. And we also have the Frivolous Lawsuits Act. So if you got to pay $560 to get your case in court, and maybe it was just about a guard tearing up a $50 pair of jeans. You understand what I'm saying? So the process is just crazy. One other thing before I let you continue, when you talked about the Slaughterhouse case and the cases that came after it with the 14th and 13th Amendment, the pro discriminators the argument was basically, if the blacks are not man enough to protect themselves, then they don't deserve the right of the federal government to protect them. The Professor Charles Lane wrote a book about it. It's called The Day Freedom Died. It's when the Supreme Court made these rulings. So if you guys get an opportunity, try to get those books. The Day Freedom Died by Charles Lane. It will break down the Slaughterhouse case and all the way up to, as a matter of fact, Yusuf, you should write a book. But thank you, guys.
Thank you. I appreciate that, Curtis. I'm going to definitely look into that book because it was a huge decision that came out of that case. Damn, something you had just said that I wanted to respond to, but it'll come back to me. So another ruling that came out of the civil rights cases was it's never been doubted, therefore, that the power vested in Congress to enforce the appropriate legislation includes the power to enact laws, direct or primary, operating under the acts of individuals, whether sanctioned by the state legislation or not. You're going to hear that as a common theme. Many of these cases reach that same determination that, Congress has the power to enforce legislation. And it went on further to say it was for that purpose that the second clause of that amendment, Section 2 of the 13th Amendment, which says that Congress shall have the authority by appropriate legislation to carry into effect the article prohibiting slavery. Who is to decide what that appropriate legislation is to be? The Congress of the U.S. And it is for Congress to adopt such appropriate legislation as it may think proper, so that it be a means to accomplish the end. And so all of the cases that came after the civil rights cases basically followed this same ruling. They just took that hands-off approach. And if it wasn't something dealing with a private individual being subjected to involuntary servitude, the court just deferred to the civil rights cases. Then came the Bailey versus Alabama decision. And in the Bailey versus Alabama decision, it was pretty much the same thing where you had a person, Bailey contracted to work on a farm for a year at $12 a month. He quit after a month and did not return the $15 advance that was given to him. Under Alabama law, Bailey's act was criminal. He was convicted and sentenced to 136 days of hard labor under the Alabama peonage law. The court ruled that the law was a restriction on his personal rights. Judged by its effect and not by its pretense, the law violated the 13th Amendment. Involuntary servitude meant more than slavery. But again, this is a situation where this is something that started outside of the courts, and it was still dealing with labor. It's still not dealing with forced work or the court dealing with what is the term, what is involuntary servitude or slavery within the prison system. And they made a similar ruling in 1944 in Pollock versus Williams. So we keep hearing this recurring theme of Congress doing something. So Congress started passing certain little laws over the time. So there was the Hawes-Cooper Act of 1929, which banned the importation of convict-made goods from other states. Then in 1935, the Ashurst-Summers Act came along, and it made it unlawful to knowingly transport an interstate or foreign commerce goods made by convict labor. And then in 1936 came the Walsh Heeley Act, where it banned convict labor on federal procurement contracts in the manufacture, production, or furnishing of any materials, supplies, articles, or equipment used in government contracts where the amount thereof exceeds $10,000. So it's good to have this stuff in your arsenal when you want to start challenging your state constitutions and the involuntary servitude and slavery within those systems, to see how they were applied in your state, if they exist within your state legislation. And I see that there's a hand raised. Abolish Slavery National Network.
I just want to say, yes, me. I just wanted to say also that all of those things are being violated right now. We are importing goods across state boundaries and national boundaries made by inmates here in the United States. When you get on a call bank, like with A&T, for instance, people are calling from all over the world. So this is already being violated, every one of those.
It's funny. So as we'll see later on, we'll see why they're able to violate these. If you can hold off for a second on that one, Max.
Yeah, I got you. Go ahead.
Okay. So in 1963, there was a case called Draper versus Ray that was held in the Ninth Circuit of the U.S. Court of Appeals. And it was determined where a person is duly tried, convicted, sentenced, and imprisoned for a crime in accordance with law, no issue of peonage or involuntary servitude arises. The 13th Amendment has no application where a person is held to answer for a violation of a penal statute. So basically, they're upholding the exception clause. In 1968, there came Jones versus Alfred H. Mayer Company. And it said the 13th Amendment abolished slavery and established universal freedom. The enabling clause, which is section 2 of the amendment, granted Congress the unqualified power to abolish all institutions and practices resembling slavery instituted by public and private actors. It was for that purpose that the second clause of the amendment was adopted, which says that Congress shall have the authority by appropriate legislation to carry into effect the article prohibiting slavery. Who is to decide that appropriate legislation? I think I'm guilty of a copy paste error right here. But we mentioned this before, that Congress has to determine what the appropriate legislation is. In 1970, there came a case, Holt versus Sarver. This was the U.S. District Court, Eastern District of Arkansas. And there was a farm, Cummins Farm in Arkansas, where, they would just work to the bone. And so the court ruled that life at Cummins wasn't slavery because the state does not claim to own the bodies of its prisoners. I'll read that again. The state does it wasn't slavery because the state does not claim to own the bodies of its prisoners. Work on the farm was servitude, and there is no doubt whatsoever that the servitude was involuntary, but it's equally clear that this servitude has been imposed as punishment for crimes whereof the inmates have been duly convicted. The court is not persuaded that the system violates the 13th Amendment. When Congress submitted the 13th Amendment to the states, is the same case going on. It must have been aware of generally accepted civil convict labor policies and practices, and the court is persuaded that the amendment's exception manifested a congressional intent not to reach such policies and practices. So this court was even saying, you know what? When they wrote that 13th Amendment, they knew what was going on inside of the prisons. And basically, if they wanted to change what was going on inside there, they would have written it into the law right then and there.
That's proof of intent.
Right. That this is what this court believed. This is the Eastern District of Arkansas in 1970. They said, look, if they wanted it to be anything else, they would have written it as something else. So here's a peculiar case. In fact, someone just, what did she say? Oh, Theta. Did you have anything to add about that, Theta, about Cummins? You said you took a field trip there.
Yes, we were in high school. I grew up in Arkansas.
Okay.
So the field trip to Cummins was they were doing some sort of type of scared straight type of thing where we all had to go to Cummins and and see what it was like in the prison. So
they still had labor and everything. They were out in the fields working the farms.
And here I am now on this phone call with y'all.
Right. 52 years later.
Yes.
Oh, I'm sorry. I didn't mean to put that out there because now that kind of like gets people to be able to calculate your age, right? So here's another case, Jones versus North Carolina Prisoners Labor Union. So you had incarcerated individuals at one prison in North Carolina, and they were trying to form a labor union, and they were trying to make it system-wide. So the court ruled, and this was a U.S. Supreme Court case from 1977. It said, while litigation by prison inmates concerning conditions of confinement challenged other than under the 8th Amendment is of recent vintage, this court has long recognized that lawful incarceration brings about the necessary withdrawal or limitation of many privileges and rights, a retraction justified by the considerations underlying our penal system. And it went on further to, I did have another slide. Oh, no, I didn't. So the case further went on. It was mentioning that basically they didn't have the ability to organize and form a union, because if they were able to form the union, then they could also start establishing what rules would go on within the jails. So that's why the court shot that down. What's up, Max?
Oh, I just wanted to add a comment. You know,
Sure, absolutely.
The court uses a lot of legalese, but where they said lawful incarceration brings about the necessary withdrawal of limitations of many privileges and rights, what they were saying is that the 13th Amendment takes away all your constitutional rights. And the only thing you get, as I stated earlier, is what they decide you're supposed to have rights.
Exactly. So going back to when we were talking about these acts here, in 1979, Congress passed the Justice System Improvement Act, which is known as the Persei Amendment, and it permits waivers of the Ashurst, Sumners, and Walsh Heeley restrictions on interstate sale of prison-made goods and sale to the federal government, provided that, did I miss something? It gave certain stipulations as to how they can do it. And they just basically made everything legal for it. So it just completely bypassed it. You can refer to the Persei Amendment. Again, copy paste error going on here. And so the Persei Amendment also created what's called the Private Sector Prison Industry Enhancement Certification Program, better known as the PI program. And this was the first step in allowing private companies to employ prison labor, since most business markets cross state lines. So this kind of like opened the door for private prisons to start being built. Max, is your hand still up, or?
No, it was left over, but
okay.
yeah, you're right. We're moving into the Reagan area now, where they started asking for-profit private prisons to move into the United States.
Right. So then, there are just tons of cases that occurred between 1979 and this case coming up in 1990, where the courts just continued with all of the previous decisions, that they just basically dismissed all complaints and just said, Congress has the lawful authority to adopt legislation, blah, 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 blah. Then came Mcgarry versus Mississippi Department of Corrections. This was a U.S. Court of Appeals case, the Fifth Circuit in 1990. And it stated, now this is where they start, making more formal statements about the constitutionality of prison labor. So it says, compelling an inmate to work without pay is not unconstitutional. The 13th Amendment specifically allows involuntary servitude as punishment after conviction of a crime. And it said, compensating prisoners for work is not a constitutional requirement, but rather is by the grace of the state. So this is what the court, just basically told everybody. Say, look, and now they force you to work, but they can force you to work without pay. And they're saying it's not unconstitutional. And again, they would still refer back to Congress has the authority to do something about this. The courts don't. This is what they're clearly telling everyone in these cases. Another case that came out that year, Watson versus Graves. This is also in 1990 and also in the Fifth Circuit. So basically some of the same judges that ruled on Mcgarry are also going to be ruling on Graves. And it says, this court has held that the requirement that incarcerated prisoners work without pay does not constitute involuntary servitude in violation of the 13th Amendment. A prisoner who is not sentenced to hard labor retains his 13th Amendment rights. However, in order to prove a violation of the 13th Amendment, the prisoner must show he was subjected to involuntary servitude or slavery. The court answered that it was irrelevant because the plaintiff had not been subjected to involuntary servitude. If the prisoner has a choice, there is no involuntary servitude. Work without pay does not constitute involuntary servitude. And what they said within this case is basically, even if there are court rules establishing that, or prison rules that establishes, certain penalties for not working, he's still making the choice whether or not to do those. They're not seeing it as a form of force that you can be sent, you can be put in solitary confinement, or you can lose certain privileges. They're still not considering that force. Max?
Oh, yeah. I just want to point out that that's in the Harvard Bellagio guidelines on slavery, where it says that if you're using coercion, for instance, or deception, that it still constitutes as slavery. Sam could probably tell you a lot of, so could Curtis, about whether or not you do a job. Like at New Jersey, where we've talked about on air, where if you refuse to work, that's a violation that is in the same category as if you had killed somebody in New Jersey prison.
Right. So they're saying the only remedy in this case is really refusing to work and then suffering the consequences of whatever the prison rules says are the consequences of not working. But it's still your choice. Sam or Curtis, did you all want to say anything?
I think you're doing a great job, and I would like to just continue to listen.
Okay, thank you, brother. I appreciate that. So next came this case, Vance Kike versus Peters. This is 1992, U.S. Court of Appeals, the Seventh Circuit. The court said that there is no federally protected right of a state prisoner not to work while imprisoned after conviction, even though that conviction is being appealed. Prison rules may require appellant to work, but this is not the sort of involuntary servitude which violates 13th Amendment rights. And again, within the case, they said the same thing. Congress has the authority to do something about it. So then I just fast forwarded it because I just kept coming across a whole bunch of the same cases saying the same thing. And so now we jump to 2002, U.S. Court of Appeals, Second Circuit, U.S. versus Nelson, and contrast the Section 1 of the 14th Amendment, which famously includes the language, no state shall. Then it says Section 1 of the 13th Amendment eliminates slavery and involuntary servitude generally, and without any reference to the source of the imposition of slavery and servitude. Accordingly, it has been recognized from the amendment's enactment that Congress's powers under the 13th Amendment are not limited by any analog to the state action doctrine that was early deemed to restrict the 14th Amendment. The 13th Amendment, unlike the 14th, in and of itself reaches purely private conduct. So now they're laying out to say, look, the 13th Amendment is only dealing with the private individual. It's not even dealing with institutions. This is only a person cannot force someone into a slavery or involuntary servitude. Because in the 14th Amendment, they came straight out and said no state shall, but they left that language out of the 13th Amendment. So their determination is that since they didn't put that in the 13th Amendment, then it's not applying to states. Anybody want to chime in on that one? Any feelings on that one?
I'm like Curtis, I'm rolling with you on this one right now, but I do see how it has unfolded, where the courts from the 1800s, just 6 years afterwards, said that you are slaves of the state. And then Congress did not counter that. And because of Congress immediately after slavery did not counter that, all the way up to 2022, we're still assuming that's how it should be.
Yeah, that's the common theme. And you noticed up to this point, I still haven't said, well, Congress went back and they clarified what they meant in the 13th Amendment. Nope, we're still under the same thing. What's up, Sean?
So on that last case, the U.S. versus Nelson, you said that the 13th Amendment only applies to private conduct. Does that mean private citizens, or does that include private corporations?
And again,
corporations a citizen.
Right.
Just as a citizen?
So it says the 13th Amendment in and of itself reaches purely private conduct, but it didn't go any further to establish what it meant by private. But we do know that there's a distinction between a natural person and institution or an entity as being a person, but again, the court just basically said if it's not the government or the state, that's where the 13th Amendment applies, that it only applies when you're dealing with a private individual. Like, I cannot force you to work. I can't force you, to be my slave. I can't do that. But if I was a prison, or if I was a private prison contracted through the state, that I could force a person into working.
And call it voluntary.
And call it voluntary. Does that answer your question, Sean?
Yes, I was just thinking, I heard private, I was thinking it might include a corporation as well, but it seems like it doesn't, so thank you.
Well,
Yeah, they're real tricky with the language, man.
Yusuf,
Yeah.
wouldn't that, to Sean's point, if you're talking about Citizens United, a corporation is a person.
Yes.
I think Max was saying that a little while ago as well. So I think the answer to your question, Sean, and I don't know whether it's actually can be borne out in what we've read so far, but if we're talking about something that's private, then yes, a corporation is private. And if I don't know whether we've gotten to a point where we're talking about persons per se, but we're certainly not talking about the state in this case. So I think that it seems as though that corporation would fall within the purview of what this is outlining.
Sure. And as we've seen in previous cases, that whenever it was a private institution, say for instance, someone's job, people always refer to slave wages and all of that stuff, working like a slave. They can't be forced to work. Say for instance, if you take any company and they just go around and they just start snatching people off the street, as they did down in, I think it was New Mexico, or Texas, where they were actually having people at gunpoint snatching immigrants off the street and just forcing them to work on these farms. See, that would violate the 13th Amendment. That's the only instance that I can think of where, when they're talking about private, that it also includes corporations. But if a person decides to go to work every single day, they work for a company and the company works them like they call it, works them like a slave at work, that doesn't violate the 13th Amendment because they have a choice to go to work or not.
Can I chime in for a second?
Absolutely.
Definitely. Remember Bob Dole? That the Dole family actually took over Hawaii and forced the indigenous people of Hawaii to go to work to the pineapple company, the fruit company, as a matter of fact. And that was a big, serious case back then. And we studied lawyers like Clarence Darrow that dealt with the labor issues that were happening out in California. Even to this day right now, and to Sean's question, everything that's not public is private. Any corporation, LLC, business is a person. So if it's not the government, then it's the private sector. So that distinction is clear. In modern day time, right now, if you want to sue your employer in the state of Louisiana, the form of law you're going through is the master-servant relationship to this day. So this in some states, I mean, I'm not talking about the whole federal scheme of it, but in some states, they still look at this this labor situation as a form of involuntary servitude because or voluntary servitude. I'm sorry, not involuntary servitude, voluntary servitude, because you're trading your time, your hour for $7 or $10 or $20 or whatever, but it's still the master servant relationship. So it's a slave situation either way.
There's one thing that I see here is very clear is that contrary to popular belief all across the country and worldwide, the 13th Amendment provides no protection versus the state.
Yes, absolutely. Absolutely. And here's another case. So I went from 2002 and I just started getting exhausted. I said, because I was reading so many cases and they all just came up to the same thing. So I said, okay, let's see what's going on nowadays. So I came up with this case, Morris versus Utech. It's a 2021 case, U.S. District Court, Western District of Washington. And it said, petitioner also contends his conviction and sentence violate the 13th Amendment's prohibition against slavery. There are no facts supporting this contention. If petitioner is claiming he performs work activity in the prison in violation of the 13th Amendment, the claim fails. Although the 13th Amendment prohibits slavery and involuntary servitude, it explicitly exempts forced labor that is imposed as punishment pursuant to a criminal conviction. And it repeats, the 13th Amendment. Then it goes on to say the 13th Amendment does not apply where prisoners are required to work in accordance with prison rules. And they cite Berry versus Bunnell, which was decided in 1994. So again, they're double, tripling, and quadrupling down on it. Once the person has been duly convicted, then they got to work. If the prison rules say you got to work, you got to work. And there's no remedy in the courts for you.
Question for you.
Sure.
Is this this is a state, this is a federal case, right?
Yes.
Okay. Wouldn't it, tell me how it would be different if it was a state case?
Well, see, the reason it's a state case is because it's going against a government entity. And so therefore they had to take it to the federal government. The only way it could be dealt with on the state level is if it was a lawsuit against an individual.
No, what I'm getting at is the difference between federal prisons and state prisons when a person brings a charge of a violation of the 13th.
Oh, I see what you're saying. Well, no, these are state cases. Most of the cases I'm reading you are state cases. They're not like federal prisoners bringing cases. They're on the state level, but because of the immunity clause, they have to bring the case in federal court under 1983. What's up, Max?
Oh, I just wanted to say also for Mark that, again, like the example we just had with the lawsuit in Colorado, the federal government is telling us that the 13th Amendment applies to every state, and whether you want slavery or not, you must abide by it in this manner. This is how it works. So without any kind of state protection, where now you have to deal with states' rights, you fall under that 13th Amendment. And the 13th Amendment is very clear. It provides no protection at all versus the state.
Very well said.
Well, when you get to the state, when you get to the state's state Supreme Court, say for example, because I would imagine that is a avenue that one could take it, or that the case could go. It could go up, it could hit the United States Attorney's Office, I would imagine. But it could also go through the state Supreme Court.
Well, the problem with that, Mark, is again, if a person is bringing a lawsuit, if a person is in prison and they want to bring a lawsuit, they're barred from suing in state. So they have to go to the federal courts. That's because of the immunity clause. I'm not the immunity clause. What's the word I'm looking for? Somebody help me out here.
Don't look at me, you're the lawyer.
It's the sovereignty. It's the sovereignty clause. The state is the sovereign. And so you can't sue the state or any of its institutions within the state court. So you have to go to federal court. So I understand what you're saying, and I get the rationale behind it, but there's just no remedy there. The court lacks jurisdiction on the state level.
Can you not, in every state, in most states, in all states, I'm sure there is a state equivalent of the United States Attorney's Office, that in our state we call it the Human Rights Commission, which has jurisdiction to pursue public accommodations and I believe employment in some housing. I guess they do that with the authority of federal statute.
So again, remember we were talking about exhausting remedies? This is another instance where if those type of remedies exist within the state, say for instance, there's the inmate advocate's office, and other offices like that, they still have to go all the way through that before they can even bring the case to court.
Okay.
You know, so, but when it comes to the courts themselves, the court on a state level, you know, a person in a state facility, then the state lacks jurisdiction to handle a claim against that institution, that it has to go federal because of the sovereignty clause or the immunity clause. It's different names used for it, but it would have to go federal. And again, we're talking about a federal amendment. And as Max explained, that the 13th Amendment is meant to be dealt, you know, across all the states. I'm almost done, everyone. So another case that came, you know, I say, you know, well, what happens when you want to do a monetary claim, you know, based on the 13th Amendment? And I came up with this case, Manning versus the United States. And this is 2021, and this was held in the U.S. Court of Federal Claims. And it says the claims court lacks jurisdiction over claims based on 4th, 8th, 6th, 13th, and 14th Amendments and the due process clauses of the 5th and 14th, because they are not money mandating. This court, however, cannot, because it does not mandate the payment of money damages for its violations. So Court of Claims said, look, there are no fines associated with violating the 13th Amendment, so there's basically nothing we can do about it.
That went over my head.
Okay, so in other words, so there are the other claims where people are making claims of so like violation of 14th Amendment equal protection, or saying that certain conditions within a prison violates the 13th Amendment prohibition against involuntary servitude and slavery. But what happens when someone wants to sue for monetary damages? You know, not only they bring in a 13th Amendment claim, but they also want to get paid because they're being violated. And the U.S. Court of Federal Claims said that they can't handle that because there's nothing monetarily attached to any of those amendments. They basically can't do anything about it. Does that answer your question?
Yeah, I think so. I think what you're saying is that the amendments don't clearly state that monetary monetary option is even available.
That's exactly right.
Okay.
Yeah.
Yusuf,
Yeah.
before you move on, I just want to say that I have to leave in 2 minutes. So I wanted to just say thank you again for participating and giving us this vital information that helps with our understanding and presentation of our own case. I appreciate your time. I've got to work with Oregon in about 5 minutes to make sure that they have the ability to start taking donations and stuff like that. And I hope that the rest of the team hangs on afterwards to discuss these things amongst yourself, because I'm sure you've got questions and have come to certain conclusions. But for me, it's very clear the 13th Amendment does nothing. There's nothing they can do versus the state. And they've shown that over and over again. And it's not because it's a mistake, it's because that's how they want it. So you can't challenge this. All right.
There it is. All right. I see you in the air tomorrow, brother.
Be on the air tomorrow. Savannah, you got the rest of this. Peace, everybody.
Peace.
All right, thanks.
Peace, Max.
So, just like Max was basically saying, the summary conclusion is there's nothing that you can really do against the state. So then I started coming up. So here was a case right here that was very interesting. It's called Mcgarry versus Polito. It's from 2012, U.S. Court of Appeals. And so this person, his name was Finbar Mcgarry. He was in county jail. He was a pretrial detainee, and they forced him to work. He had to work in the laundry. And so he decided to sue the jail. And the U.S. District Court wrote that Mcgarry's 13th Amendment claim was without merit because his laundry work, quote unquote, was nothing like the slavery that gave rise to the enactment of the amendment. So in other words, that judge was saying, because he wasn't being whipped or he wasn't being sold or all of the other atrocities that came with chattel slavery, then he had no claim. But the U.S. Court of Appeals, they determined that Mcgarry did not have to prove that his existence was akin to those of African slaves before abolition. It says involuntary servitude is not limited to chattel slavery-like conditions. And it said, again, this amendment was intended to prohibit all forms of involuntary labor, not solely to abolish chattel slavery. But again, the reason this was applied to him is because he wasn't duly convicted. And so therefore, he wasn't, they couldn't legally subject him to involuntary servitude and slavery. And that's why he got the relief in that one. And there's one other case, I didn't make a slide for it, but it shows you I wanted to show the ridiculousness or, again, the intent and knowledge that they have when it comes to the 13th Amendment. There's a case that made national attention, many years ago. It was called Tilikum versus SeaWorld. And this is where Peter went on to sue SeaWorld on behalf of the 5 orcas that were there using the 13th Amendment. And the court basically said in that case, look, the 13th Amendment is meant to be dealing with humans. It's a human condition. And it said that in order to hold on, let me scroll through my notes because I don't want to freestyle that one. So in essence, the court was really just saying that since they're not human, then the 13th Amendment doesn't apply to them. That was their ruling on that one, and as we stated before, there's someone. Oh. Okay, just making sure I didn't miss any comments in the chat or something like that. So that was just a sidebar when that one really didn't have anything to do with the presentation, but just showing that the courts know how to distinguish a pretrial detainee from someone that's being held in state. So that made it clear that they know the difference, because they said within this case, they basically said that because he was a pretrial trainee and pretrial detainee and hadn't been duly convicted, then they couldn't force him to work. He didn't have to work based on the rules of the jail. And that's why they ruled in his favor. So just in closing, I'd like to quote what Representative Martin Thayer of Pennsylvania said when they established the 13th Amendment. So he said, when I voted for the amendment to abolish slavery, I did not suppose that I was offering a mere paper guarantee. And when I voted for the second section of the amendment, I felt certain that I had given to Congress ability to protect the rights which the first section gave. So again, going back to the intention that this wasn't meant to be symbolical, it was meant to be intentional. But as we see throughout every case that I presented, and I mean, it's hundreds of other cases just like it, maybe even thousands, where every case comes down to one thing. Congress has the authority to do something about it. So until Congress steps up and they enact a law that actually takes away involuntary servitude, takes away slavery as punishment for a crime, then that's going to always be allowed. The courts are going to be hands off on it. And this is why we all are here today where we are. So that's the presentation for today. I'm open for any questions if anyone has any questions.